Travis County. One day, the Western Commissioner and I were driving out to check on the progress our guys were making on rebuilding a bridge, and I hit a big pothole. And he goes, golly, I'm gonna call Road and Bridge right now and get them to fix that. I said, Larry, you just violated the sunshine law because you made a decision and not had it on the agenda for our meeting. So not only would he be charged with $100, but me, I consider an innocent party sitting there driving the truck, I would have got charged $100 too under this legislation. With that, I'll be happy to answer any questions.
Okay, are there any? Senator Everett.
What was the date and time of that conversation?
I think statute of limitations has ran out. That was around 2000.
Anyone else? Thank you, Todd. Anyone else to testify in opposition? Okay, seeing none, that'll close the hearing on Senate Bill 843.
Thank you, Mr. Chairman.
We save the best for last. I will now hand over the chair to Senator Everett.
Stand and present Senate Bill 824 for Senate tradition.
Thank you, Mr. Chairman. Bob Dixon, District 30, presenting Senate Bill 824. For brevity's sake, Mr. Chairman, this is the bill that I just actually discussed at length on the Senate floor that was adopted as an amendment to Senator Parsons' bill, the multi-county prosecuting attorney bill. It allows counties within a multi-county judicial circuit to, upon their decision to go together and have a district attorney go to a single prosecutor. Rather than go through a lot of explanation on the bill, I think what I'll do is just open it up for questions, and then I think the witnesses that I hope are still here can answer.
Any questions for Senator Dixon? Seeing none, are there any witnesses in support of Senate Bill 824? Please just identify yourself and proceed.
Good evening, Matt Soldy, Stone County Prosecuting Attorney and President of Missouri Association of Prosecuting Attorneys, here in support of Senate Bill 824. And just to expound a little bit on some of the discussions that were held earlier, prosecution in the 21st century requires expertise and specialization. For example, I begin a murder trial next week, which will involve DNA, computer forensics, cell phone tower technology, cell phone records, blood splatter evidence, human pathology and physiology, ballistics, and psychology. Other crimes such as child sexual abuse, domestic violence, drug prosecutions, and internet crimes all require some degree of expertise and specialization. There are 115 prosecutors' offices in the state. 63 of those elected prosecutors are full-time, 52 are considered part-time. The largest offices have as many as 50 attorneys handling thousands of felony cases per year. Those same offices have just as many or more support staff as they do attorneys who provide victim services, collect bad checks, restitution, and delinquent taxes, do investigations, research, and manage aspects of the offices. Our smallest offices have a single part-time prosecutor and are expected to provide all of those same services and levels of expertise with perhaps a single staff person. Less than half of our offices have victim advocates. We believe that every citizen deserves to have a locally elected full-time prosecutor with sufficient staff and resources to provide adequate victim services, protect citizens from criminals and criminal activity, and successfully prosecute those who commit crimes. We also know that it's not economically feasible for every county to be able to provide all of those resources, but we think those levels should be made at the local level. Senate Bill 824 addresses many of those concerns by giving local county governments the option, by agreement with other counties, to combine prosecutor offices in a judicial circuit into prosecutorial districts, provide pay raises to part-time prosecutors where the prosecutor agrees to take on additional activities or duties, and promotes career prosecutors who can develop the expertise that I mentioned before. Last election, we had approximately 40% turnover, and that's not unusual for our organization. I stress again, this bill gives local control to county governments, and there's nothing in this bill that is mandatory to any county or any person. It does allow individual counties to determine what is the most efficient, economical, and best way for them to provide maximum prosecutorial services to their citizens. I would take any questions.
Any questions for this witness?
Mr. Chairman,
Yes, sir, Senator Shea.
so if everyone did this, and I understand it's voluntary, you go from 115 prosecutors' offices to 45.
If they all did it and all of the counties within each district did it, or each circuit did it, then you would, yes, you'd be down to 45 elected prosecutors.
Any other questions? Being none, thank you for your testimony, Matt. Any other witnesses in favor of Senate Bill 824? Seeing none, are there any witnesses in opposition to Senate Bill 824? Seeing none, that concludes the hearing on Senate Bill 824, and we will proceed to Senate Bill 583. Senator Dixon.
Thank you, Mr. Chairman. Bob Dixon, Senate Bill 583. This deals with medical malpractice cases. It's the same bill essentially that I introduced last year. Currently, in medical malpractice cases, plaintiffs are required to prove non-economic damages by a preponderance of the evidence. This act would change the evidentiary standard, something that was not addressed in the Watts case because it is clearly the purview of the legislature. We changed the evidentiary standard for non-economic damages in medical malpractice cases to clear and convincing. Last year's bill was Senate Bill 64. Be happy to answer any questions. But I do want the record to reflect that the white coats did not come from me this time.
Questions?
They came to get somebody else.
Seeing none, do you have witnesses or just call it?
I don't know.
Any witnesses in favor of Senate Bill 583?
I'm afraid my friends are going to testify against my bill.
Any witnesses in opposition to Senate Bill 583?
Yes, sir. Kevin Davidson on behalf of the Missouri Association of Trial Attorneys. Looking at this proposal, what gives us greatest pause, I believe, is the difficulty the juries have in understanding the burden of proof. The burden of proof instruction, looking back on it, has taken a lot of work. And what this proposes to do is create two burdens of proof. Juries get a pack of instructions, they take it back to the jury room with them, and they apply the burden to the facts as they've heard them. Giving them two burdens is going to cause confusion for that jury. It's going to lengthen the trial process because they're not going to know necessarily which burden to apply it to which question that's posed to them. Secondly, they're already assessing categories of damages. This is putting another layer on top of that. Also of concern is the fact that the burden is much, much higher. Clear and convincing is tantamount to a criminal standard. Where we have it today is for civil commitments to the mentally ill and for punitive damages. So we have damages, we have people are going to lose their freedom. That's when we use clear and convincing, or when we're seeking to punish. But in the medical malpractice context, we're simply seeking to compensate. So the added complexity and the higher standard just doesn't make sense in a compensatory system.
Any questions for this witness? I have one, Kevin, and because in the hearing just prior to this, we heard testimony about a murder case and all the various aspects of evidence that will be entered in that, and that would likely be a jury trial, wouldn't it?
Yes, it would.
And you're saying the jury that could handle all of that evidence could not handle the division of these two levels of proof
in your suggestion, Senator, I believe that jury would have a single burden of proof in a criminal context.
Right, but you're saying this adds so much complexity that the juries can't be trusted?
Well, the medical malpractice cases, they're already being confronted with such complexity on the factual aspect. They're having to learn new medicine and to try those facts. One of the things I considered was we're entrusting the jury to be the finder of fact. And by adding a layer of complexity with 2 burdens of proof, we're adding to the job that's already very, very difficult as compared to, say, a car accident case or premises liability case. In the medical negligence context, it's very, very difficult for them to parse this evidence. They do it, but it's a tall order, and it's a tough task, and I think this is just going to make it tough.
Thank you. Any other questions? Seeing none, thank you for your testimony. Any other witnesses in opposition to Senate Bill 583? Seeing none, that will conclude the hearing on Senate Bill 583, and we'll go to Senate Bill 585. Senator Dixon.
Thank you, Mr. President. Mr. Chairman, just tell the committee, I would have postponed the hearing on these 2 bills, but I think we have folks coming from out of town. Senate Bill 585, Bob Dixon, District 30. Currently, punitive damages cannot exceed the greater of $500,000 or 5 times the net amount of judgment or the plaintiff. This act would modify the language to provide that punitive damages cannot exceed the greater of $500,000 or 5 times the net amount of the compensatory damages awarded to the plaintiff. This really grew out of a case. Well, I won't go into details. That's the changes.
Questions for Senator Dixon? Seeing none, are there any witnesses in support of Senate Bill 585? Seeing none, are there witnesses in opposition to Senate Bill 585?
Mr. Chairman, Brian McAllister for the Missouri Association of Trial Attorneys.
And we're not getting them all.
No, that's quite all right. We stand in opposition to this bill because it is a fact that in trials, punitive damages are very rare. They are very rarely submitted by the court, and only in those cases that are the most egregious. We are concerned that what this bill will do is in cases of workplace discrimination, race discrimination, disability discrimination, where sometimes the jury's compensatory damages might be low, that this would then create a multiplier for punitive damages that is also low. And this is, again, in cases that are very rarely submitted, punitive damages where the conduct is egregious, and the trial judge has already made a ruling that the conduct is egregious enough for punitive damages to be awarded by a jury. This multiplier would change from a multiplier of 5 times the judgment, which can include compensatories plus attorney's fees awarded, and change it to the 5 times the compensatory multiplier, which could be significantly lower. Punitive damages are often called smart damages, and you can look at that word smart 2 different ways. Make it smart as in hurt a corporation, punish a corporation for bad conduct, or make them smarter the next time this decision comes around whether to discriminate or not to discriminate. This is not something that we should reduce. This is something that we should encourage juries in the egregious cases to award.
Questions for this witness? I just have one, Brian. You said that the punitive damages are rarely awarded. Can you be more specific about what rarely awarded means?
In 24 years of practice in trying cases, I've had 2 where punitive damages have been submitted by a court. It has to pass the test of the trial judge first, and then the jury has put the question whether they think punitive damages should or should not be imposed. Then there's a second phase of the trial where damages are actually assessed. And what can come into play in that second portion is the net worth of the corporation that the punitive damages are being awarded against. Let's take, for instance, a recent case against AutoZone. It's a $1.7 billion corporation. And the jury saw it fit to award punitive damages that were actually higher than the multiplier in the existing law. If we further reduce the multiplier by saying it's only going to apply to compensatory damages and not total judgment, then that means that the large corporations who commit those egregious acts are not going to be punished severely enough to prevent them from doing it again.
Okay, thank you. Thank you for your testimony. Any other witnesses in opposition to Senate Bill 585? Seeing none, that will conclude the hearing on Senate Bill 585. And thank you to the motion for adjournment. Second. All those in favor? That's perfect.
Senator Shaver. Sorry, it's 10 o'clock and I'm asking you a question. World War II Trust Fund. World War I Trust Fund was created last year. In the well, you know. Okay.
Either that or I took the same copy.
I don't know this. Bad enough is next, he's usually his buddy.